SJC-11383, John P. Harrington v. William M. Costello et al.
All right, let's proceed.
Good morning, Your Honors. My name is Frank L. McNamara, Jr., and I represent the plaintiff appellant, Father John P. Harrington, who is in the court today. This appeal presents this tribunal with a unique opportunity to define with greater clarity and particularity that quantum of knowledge that a putative plaintiff must possess before the statute of limitations in a defamation case begins to accrue. Harrington submits that he, a diligent plaintiff who did everything he could to identify the identity of the defendants as defendants, should be accorded the sorts of relaxed discovery principles that this court and other courts have gradually extended to similarly situated plaintiffs.
Well, may I ask you, just hypothetically, if we agree with you, would that mean that under certain circumstances, a party might have 25 years, 50 years before they get the information they need to pursue a claim?
That's a good question, Chief Justice, and it's a hypothetical one.
I understand it's
I would
a
argue that
hypothetical.
in that context, that plaintiff would be hard-pressed to show that he was diligent.
Well, what's the outer limit then? Maybe we can work that way.
Well, I don't know what the outer limit is. But I know it when I know a limit when I see it. But I don't know how to tell you.
There has to be a limit at some point.
Well, in the Henderson case, for example, that this court decided, the limit was in excess of 10 years. Conceivably, I suppose there is a set of hypothetical facts whereby you could have a lengthy accrual period. The problem with that is the purposes of the statute of limitation are to provide repose, and one would have a difficult time arguing that repose is served by that length of accrual. But the point is that this tribunal and other tribunals have shown over the recent decades a proclivity to extend discovery rule principles to a plaintiff who really doesn't know reasonably and in good faith those critical, vital elements around which a cause of action coheres.
But doesn't your argument in that regard depend on this sort of hypothetical teasing out that the plaintiff would say to himself, well, I know that Father Perry and Father Costello are not the right defendants because they have a conditional privilege. I mean, he's not a lawyer. Why wouldn't a person in that situation be faced with, look, this is defamatory material that they have published to the religious instructors. I'm injured, ergo, I sue. I mean, it's you've got to import this whole legal analysis that seems, I can't fit it in there.
I would call it nuanced, Your Honor, as opposed to applying the garden variety analysis that the lower courts applied, whereby the cause of action is deemed to accrue as soon as the harm is perceived. This case, because of elements such as the conditional privilege, the fault requirement, and constitutional opinion that attaches to something that is uniquely subjective as the accusation of stalking, this plaintiff just simply did not know whom to sue. Take Perry and Costello. He saw these two men, one of whom was his immediate supervisor, right, one of whom was the vicar general of the entire archdiocese. He saw reasonably that these two men were in a position to communicate the stalking accusation to each other, and in so doing, to advance vital public and private interests.
Okay, so could he have brought the lawsuit against the two defendants then they might not plead conditional immunity. They may not plead it, but let's wait and see. Let's see if they are going to plead it. So he sues them, and they raise it in their answer. Can he then ask for discovery to take the depositions of the two to determine who the person is?
That's an excellent question. Modesty almost forbids my saying that I anticipated it and treated it on page 19 of my reply brief. And that's what appellees have contended throughout. Harrington could simply file a suit against Costello and Perry. Let's pursue that. It's easy to say, but such a claim would have been highly speculative in light of the defenses that were available. In addition, any moderately capable defense counsel would have asserted the fault requirement, the conditional privilege, and the constitutional protection of constitutional opinion. They would have moved to dismiss such a claim.
But what about the discovery?
Well, whether Harrington would have discovered the truth during discovery, during depositions, is a nice question. It's not guaranteed that he would have discovered the identity of LeBrun in the course of discovery, or if he would, how long that would have taken him. But more fundamentally, I think it offends fairness, as this court said in the Gore case, to require of a plaintiff the gift of prophecy. Furthermore, I question, with all due respect, whether it is sound judicial policy to encourage the commencement of litigation in anticipation that some deus ex machina might appear out of the sky in the course of discovery, pendante lite, as the court said in Gore, which will manifest itself and make everything all right for the plaintiff. Worse, in this particular case, such a suggestion, such a blueprint, overlooks the requirement of Chapter 233, Section 20A, which extends the confessor-penitent privilege to any people who seek spiritual and other guidance from people like Costello and Perry. And finally, I think that type of approach underestimates the reach of Rule 11 and the degree to which conscientious practitioners observe it before preparing complaints.
Well, isn't the essence of your argument that we can't require somebody to file a suit which would be in violation of Rule 11, and then say, because you didn't do that, you're out of luck? I mean, isn't that the essence of what you're arguing?
Well, that's one way of looking at it. I think the essence of what I am arguing is that the identity of a defendant is at least as critical an element in the tort, and in this case the defamation context, as all the other elements that exist. Standard of care, whether it is breached, harm, damages, and the identity of the defendant. My client was in at least as bleak a position as were other plaintiffs to whom this very tribunal has distended relaxed discovery principles. And indeed, he was in the same position as those of other plaintiffs in other jurisdictions who have been the beneficiaries of relaxed accrual principles. This court is uniquely situated to extend these accrual principles. You've done it before.
If you prevail, what's the rule that would come out of this case?
The rule would be case-specific, which is exactly what the United States Supreme Court has been advocating since the case of U.S. v. Kubrick. We are getting away in this country to a categorical, non-nuanced examination of the discovery rule. It would be, your decision would be based strictly upon the facts of this case, which are very narrow. They involve the conditional privilege. They also involve the requirement of fault. They also involve constitutionally protected opinion. But you wouldn't have to reach those.
By doing it without conditional privilege, this case is a no-brainer, right?
Not necessarily. Not necessarily. This case rests on
Defamed, and publication by persons known.
Yes. But there is a fault requirement. There is a fault requirement since United States versus Gertz. The four elements of defamation are, and I'll quote the restatement of torts. You need a defamatory and false statement. You need an unprivileged communication to a third party. 3, you need fault amounting to at least negligence. And 5th, you need harm caused by the publication.
So if you take the conditional privilege out, why don't you have those?
Pardon me?
If you take the condition...
Because there's a fault requirement. There's a fault requirement since the Gertz case.
Yes.
What about the conduct of Costello and Perry, when examined in that critical interview, rose to the level of fault?
Well, if it's false, as your client says it is, that's the fault.
Not if there's no negligence on the part of the transmitter of the false statement.
Do you mean fault, or do you mean under Chapter 260, Section 12, that there was some affirmative misrepresentation about the identity?
Well, there was affirmative misrepresentation.
But is that the same as fault in your mind? Is that what you're arguing is fault?
It's more than fault. It's malice. An affirmative representation, when Costello...
Do you need the affirmative misrepresentation if you didn't have the privilege?
I'm not sure I follow you, but when Costello said...
Let me put it to you a different way. You have a hit-and-run automobile accident. You don't know who drove the car. You know you've been hit. I mean, that's obvious. But you find out 10 years later who hit you. Can you bring a suit?
It depends on the diligence, in part on the diligence of the plaintiff.
So without a misrepresentation as to the identity, you could, no matter how you try, if the plaintiff tries hard and is diligent in trying to locate the driver, and there's no misrepresentation on the part of the driver of this hit-and-run accident, you conceivably could bring an action 10 years after the accident, in your mind.
No, I don't think you could do that.
Why not?
I don't think you could do that. Because, I mean, number one, it's not a defamation case. In a defamation case, you do need the element of fault. And the purpose of this discussion is what would happen if there were no conditional privilege. I've addressed this in my brief, and I believe we can still prevail in the absence of the conditional privilege. I think the conditional privilege is far and away the best window through which to view this case.
Yeah. If you're right, could you help me as to how this plays out? Because I take it the defendants in the case can still plead the statute of limitations. Is it a jury question? Does the judge decide? Do you have to listen? Does somebody have to listen to the testimony of Brune or LeBrun on the matter of whether he did or didn't make this statement?
First of all, there's been no discovery in this case. So a lot of what did LeBrun know, and what was the nature of the communication between LeBrun and Father Harrington on November 6, 2007, has yet to be explored. The record in this case is very immature. I would presume that in the course of developing a record in this case through discovery, facts would be adduced, which would give the defendants an opportunity to bring this case forward as one under Rule 56. So in a way, they really haven't lost anything if my client is given his opportunity to have a day in court. We'll have a more mature record. We'll have facts adduced that will shed light on exactly what degree of fault was exhibited by Costello and Perry, the defendants, and we'll be in a better position to make a just and fair determination. My point here is that this is a case where my client really didn't know whom to sue. And in circumstances where, as here, that was a reality, his situation is at least as bad as those of other plaintiffs to whom liberal discovery principles have been allowed. And there is other case law cited in my reply brief where courts are increasingly coming to the realization that the identity of the defendant is a critical element in a claim. And when you have a good faith plaintiff who acted with great diligence, he should be accorded the relaxed accrual standards. And this court has that has that authority to do it. You've done it in the past in cases cited in my brief, and I would ask that you do it again because he deserves his day in court.
Thank you, counsel.
Thank you, sir.
Good morning. May it please the court, I'm Ross Kimball, and I represent the defendants in this case. The court has indicated already some issues with the plaintiff's case that I would like to address if I could.
Could I just ask you, at some point, you seem to have in your brief a good number of references to materials that I don't think are before the court as part of the record, and certainly wouldn't have been before the court in a motion to dismiss, about actions taken by Father Harrington independent of this case, or I just wasn't sure where you were getting that from, or
Your
the
Honor, thank
appropriateness
you.
of it.
Thank you for raising that issue. Where we're heading is, this is a case in which, unfortunately, the plaintiff has taken the opportunity or taken advantage of the fact that the defendants have to admit, for purposes of the motion to dismiss only, the facts of the case, and then piles on and creates a morality play about how he has been hounded out of ministry by this evil group of people acting unfairly. In one place, he talks about his zeal to identify the author of the accusation intensified a diocesan campaign to marginalize him. And he points to letters which are in the record, Bishop Coleman's records, letters at pages 21 and 22 as grounds for that statement. But in fact, those letters don't say that. Those letters don't say any. They talk about his behavior. They talk about his refusal to take a psych exam.
Two wrongs make a right?
I'm sorry, Your Honor?
So two wrongs make a right? Is that your theory?
I hope, Your Honor, we were only trying to level the playing field, but I think the court has realized that there are significant issues here on the merits and the legal arguments that we are willing to.
If I can get to those merits.
I'm sorry, just.
If I can get to those merits, let's assume that the plaintiff here, before he had information to indicate that Mr. LeBrun had not made those allegations, if he had filed a complaint against your clients saying, as far as I know, they repeated an allegation of stalking that was furnished to them by a parishioner, would you not have moved under Rule 11 and said that that's a bad faith suit? Because of course a member of the clergy is supposed to respond to a parishioner's allegation of sexual harassment.
Your Honor, members of the court, that is the standard for Rule 11 is much higher than that. It's a standard of bad faith. It's a standard of frivolity. In this case,
well, if he had no basis to say that that information was not in fact relayed by a parishioner, which he did not have until Mr. LeBrun denied it, would he not be acting in bad faith? Would he not have any basis to say that he can defeat the conditional privilege?
At that point, Your Honor, there was no conditional privilege here. And what's happened here is
I'm sorry, you're saying that that if a parishioner tells a member of the clergy that a priest is sexually harassing him, that priest has no conditional privilege when he reports that allegation to a senior member of the church?
Well, at this point, as is indicated in the complaint, Father Harrington already knew that the other clergy had gone to these teachers and to one another before going to him. The conditional privilege really doesn't attach until they come to him and say, wait a minute, there's this allegation. They're not privileged to go out and start spreading that information before going to him and inquiring as to his position on it, number one. Number two, there's no factual support in this record for the supposed belief, the supposed reliance on this conditional privilege. What we have is a lawyer's argument that was constructed on appeal. There's nowhere in the complaint, talking about the record here, there's nowhere in the complaint where the plaintiff says that I reasonably relied on the understanding that there was a conditional privilege here. There's nowhere in the complaint.
Isn't that why it's important that he learned from LeBron that he had not made the allegation? Isn't that precisely why that's important? Is because the conditional privilege would not apply if that allegation was in fact made, that if the allegation was indeed non-existent and it was the member of the clergy who had framed a fellow member of the clergy?
Well, that helps with the conditional privilege argument, Your Honor, but what it doesn't help with is that the plaintiff did not follow his duty of inquiry in this case. This is a case where he knew all the facts he needed to know that he had been defamed.
So so in response to Justice Gantz's question, if Father Harrington had brought this suit in 2008, but within the time anyway, within the 3 years, 2007, and had just named Father Costello and I'm just blocking on the
Perry, Your Honor.
Perry, those two as defendants, and alleged that they had defamed him by going to the religious instructors with this clearly false statement about stalking, you would have answered and gone to summary judgment. You would never raised anything about conditional privilege or anything. Is that right?
Your Honor, you raise a very good point. The elements of the tort itself do not include the absence of a defense. If I were defending the case, if there had been no mention of LeBron, most likely I may well have raised the defense of conditional privilege. Having raised that defense, though, and one of the members of the court asked this question, I don't believe that that's sufficient. The mere assertion of conditional privilege is sufficient to allow the case to be dismissed. Most likely, the court would have allowed there to have been discovery after that. And once there's discovery, it's at that point that the plaintiff is able to ask all of the questions about where this information came from in order to determine whether the conditional privilege is in fact fairly asserted. And one of the problems that happened here is that the plaintiff never tried. He never tried. He wants to say that it was speculative to bring this lawsuit. He wants to say that it would require a gift of prophecy. But what happens is he can't stand here before this court and ask this court to extend the relaxed standard when he never tried to do what he
I
could have
thought you
done,
had
which
said
was to file suit.
that your client was trying to protect Mr. LeBron because Mr. Harrington had made this a passion of his, and he didn't want to reveal the identity, to prevent Harrington from going to him. Isn't that what your client did?
Your Honor, we don't know those facts at this point. I
Okay, but-
believe
but
that's
they-
a suggestion that the plaintiff has made, but we don't know those
So how
facts.
can you say that? How can you say that there's a factual basis to say that there was no due diligence when, if anything, your brief says that he had made this a passion, that the search for who was the original complainant became a distracting pattern? That's part of what Justice Botsford was concerned about, what you had included. But if anything, you're saying he was more than diligent. He was crazed about the issue.
Well, he wasn't more than diligent, Your Honor. And the reason I say that is Judge Dupuy in the Superior Court perhaps made the best analysis of this case as there could be, that in terms of the duty of inquiry, Father Harrington had one simple stop to make. He could have gone to the boy's mother, Mrs. Williams, and he could have said, Mrs. Williams, you didn't say this. Did you say this? And she says no, because that's what she told Father Perry and Father Costello, according to the complaint. I understand that you spoke with a co-worker about this. At that point, Mrs. Williams, whom the plaintiff in his papers says is a credible person, a presumptively credible person, the plaintiff hears her say that, no, I never said that to any third party, to any co-worker. At that point, he knows that Costello and Perry are not telling the truth, and he can bring his lawsuit. So he has not followed his very simple duty of inquiry to go to the person to whom this comment was initially ascribed.
So what is the moral to this story? I mean, sadly, we have many allegations of clergy abuse. If an allegation is made against a priest or a rabbi, which the priest or rabbi believes to be false, he's supposed to sue the speaker for fear that the time limit will pass before he learns that the source of the allegation turned out to be non-existent?
Well, number one, again, the conditional privilege requires that it not be abused. And as I indicated earlier, perhaps the priest or the rabbi comes to the accused person first before going on. Number two, this is...
Well, I mean, of course, he comes to the accused person first, but at some point he has to report it, doesn't he?
Number two, this is a...
Sorry, try my question. If there's an allegation from a member of the congregation or a member of the parish that there's sexual abuse, doesn't the person who hears that have to report it to somebody who can investigate?
I don't believe stalking falls within the description, within the definition of sexual abuse, Your Honor. And this is a separate case. This is a specific case. This isn't a case where there's just two clergy who tell Father Harrington that Mrs. Williams has made this allegation. Rather, it's more complicated, perhaps more nuanced, as my brother counsel would like to say, because they first tell him that Mrs. Williams said it. Then they say, wait a minute, she didn't say that, but she said she spoke with a coworker.
Don't you think
And so they're aware of a third person. He's aware of a third person, and some confusion, and maybe should be on a heightened sense of something's not right in Dodge. Yes, Your Honor.
Well, I just wonder about this context. So Mrs. Williams, I don't know about Mr. LeBrun, maybe he's a parishioner too, but certainly Mrs. Williams is a parishioner of the
St. Patrick's, Your Honor.
Yeah, St. Patrick's. As a priest, Father Harrington, I mean, do we just ignore the fact, put aside conditional privilege, but we also have the priest penitent privilege here? Does that play into this at all? In other words,
Does not play into it at all, Your Honor, and I'll tell you why for a couple of reasons. The first reason is that depends on somebody coming looking for spiritual and pastoral care. And this is a case in which a parishioner is making an accusation of stalking and asking that her child be removed from a class. That's seeking relief, number one. But I can go further, Your Honor. Secondly, even the observation that Father Harrington would have made is that Costello and Perry did not believe it was privileged because they passed it on. If it's privileged, it's privilege. I can't come and tell Father Harrington after Mrs. Williams tells me, Mrs. Williams told me such and such. That's a violation. And then thirdly, Your Honor, it doesn't play in because we have in the record Father Harrington's own letter to Bishop Coleman in which he says, I told my whole congregation that I've been accused. So I think based on that, Your Honor, that the privilege does not apply here. Members of the court, in addition to these issues, this issue has been addressed in other cases around the country, in other jurisdictions, and we have referenced several of those cases in our brief, particularly at page 38, 39 of our brief, and then in footnote 18 of page 42 of our brief. Just briefly, the cases cited by the plaintiff saying that the knowledge of the identity of the defendant is now being recognized as a critical fact and for purposes of accrual of a cause of action. The Liuzzo case involved a case where the Ku Klux Klan had murdered a woman back in the 1960s, and later they determined, many years later after a Senate investigation, that the FBI had some involvement in that and had some culpability.
Well, in this case, though, Mr. McNamara is also suggesting that there was an affirmative misrepresentation on the part of the defendants, that they said that they got this information from somebody else, and that it wasn't them. Why doesn't that qualify to at least toll the statute of limitations?
Because the rule in Massachusetts, Your Honor, is that if one conceals a cause of action, that would toll the statute of limitations, but not if one conceals the identity of the defendant. It also requires an affirmative.
We've never really addressed that particular question.
I'm thinking of cases in other jurisdictions.
Yeah.
Thank you, Your Honor, and they're cited in our brief. It's also the case that there needs to be an affirmative misrepresentation as to an affirmative misrepresentation here. They lied in the beginning, and they said, allegedly lied. They lied in the beginning and said, a third person told us this. But they didn't lie in terms, they didn't conceal the fact that they had republished this allegation. They republished it. And as one of your members said previously, if there's no conditional privilege here, there's no case. They republished it. There's no support for the conditional privilege. The conditional privilege does not apply here. And therefore, right from the beginning, there was the opportunity to bring a case against the very two people who are still here in this case and defending this appeal.
All right, thank you very much, sir.
Thank you, all members of the court.